So now we've talked about the relationship with the customer, we talked about the relationship of your members or how your organization's going to be, but your next step is how to deal with your employees, all right? You have to figure out how you're going to deal with your employees. When it's just you, you don't have to worry about things like that. But when you have employees, it's changed, and there's a difference. There's a difference between an independent contractor and an employee, and the law cares. And so does the IRS cares about whether they're an independent contractor or not.
I'm Mark Olson. Luke Gibson and I have a combined 50 years in construction as fence contractors. In that time, we have both experienced failures and success. We travel the country talking with other contractors who share their experiences in hopes that their stories can make you a more successful contractor.
I've had terrible situations where I've had different types of cases as it relates to independent contractors, but I've had one in particular. My LLC thought that his person that was working for him, and it was a landscaping type company, thought that the employee was an independent contractor.
So we're talking 1099 here. Just
1099, yes.
This is something that gets, that we get this all the time. This is a huge topic,
Right.
huge topic.
Right.
And so many people think that, well, all I have to do is I'm not going to put them on payroll. This is the thought. This is what I see every day. I just won't put them on payroll because it'll be cheaper, and then I'll just pay them out, and I'm going to pay him by the foot, but I'm going to make sure that I tell him when to show up in the day. He only works for me. I'll provide him with a truck and all the tools, but he's a subcontractor.
Yeah, he's not. That's an employee.
That is 100% what so many people around the country are doing.
So you don't pay their workers' comp. You don't pay their unemployment.
That stuff's expensive. I don't want to pay any of that.
You don't pay their employment taxes.
No, that's expensive.
Nope.
I'd have to raise my prices.
And then some government official comes in and says, hey, guess what? They're not 1099 independent contractor. They're an employee because you controlled their hours. You provide them the tools of the trade. You should have W-2'd them and not 1099'd them. And because of that, you owe all the penalties for all these other things, all right? And you're liable for the stuff that they do. And so a great workers' compensation example is the guy that my employer thought, LLC employer, thought he was a 1099 independent contractor. Guy gets hurt on the job. He files for workers' comp. Comp pays it. And it's a back injury, a $100,000 back injury. Workers' comp has a hearing and they decide that he's not a 1099 independent contractor but a W-2 employee.
But if he is a 1099 subcontractor, he shouldn't be eligible, right?
He shouldn't be.
But this individual...
This case, the LLC became liable for all the bills on the workers' comp.
Because they said he was 1099 and he went and signed up, he went and claimed work comp. So $75,000-ish worth of...
On the LLC.
What did that do to the company?
Well, the company couldn't sustain that. The company ultimately ended up filing bankruptcy on that.
And it's not just that, right? So it's the injury itself and then all the continuing stuff. So there could be continuing lost wages, continued impairment.
All sort of for that. That's a mess. A back's a mess. If a person gets their back hurt, the employer has the back forever. Now, maybe through workers' compensation, but there's always problems with the back. But this question about whether you're an independent contractor or an employee raises its ugly head all the time because we haven't talked about overtime pay, all right? But if you work over 40 hours in a week, you have to pay your employees overtime. Now, there's a ton of exceptions on this. There are a ton of exceptions on this. But people fail to do that. So when they do fail to do that, a lawyer like me comes in, sues you for failing to pay overtime. I not only get the overtime wages plus the interest, but I get my attorney's fees. And oftentimes my attorney's fees exceed the wages. So I had a case once where the person they claimed to be an independent contractor was working all of this overtime, all right? And it came into me as a workers' comp case. But when I looked at the case, I said, oh, it is a work comp case. We prevailed on the work comp case, but it's really an overtime case. So we filed the overtime case. I was representing the employee. We filed the overtime case because they were not an independent contractor, but they were an employee. They were working over 40 hours in any given week. And they ended up paying us not only the wages, but my attorney's fees. So that distinction is super important. And one of them that just a lay person doesn't know. But I've had employers where they will come into me and say, hey, all of my employees are independent contractors. No, that's not the case.
What are some of the big red flags that say that is not a 1099 subcontractor, that's an employee. There's some big red
Big
flags.
red flags. If you supply them any part of the tools, if you supply them any part of the tools of the trade, if you control what they do, you say you have to be here at 8 o'clock in the morning. If you tell them or you work them so much that they can't work for anybody else.
That's a big one.
That's a big one. Yeah.
Because I know there's people out there, they're my subcontractors, they don't work for anybody. That's a problem.
Right. And the agreement. So if you're coming into me and you say, hey, I want Jim here to be a 1099 independent contractor for me, the first thing you and I are going to do is we're going to write an agreement between you and Jim. And what's it going to say? Independent contractor agreement. And we're going to go down the list of every one of those factors, and we're going to say, we're not supplying you the tools. You can come and go as you please. We expect the job to be done at this certain time period for this certain price, blah, blah, blah. But every one of those factors, we're going to issue them a 1099, which is not dispositive, but we're going to issue them a 1099. But we're going to go down every one of those factors that makes it look like that he's an independent contractor. And we're going to use that agreement, whoever comes after us and says that's really an employee, we're going to use that agreement. But that agreement in itself is not enough. It has to be factually true that he factually is really an independent contractor.
And it would be things like if they have people working for them, do they have their own work comp?
Yes.
Do they have their own insurance policy?
Yes.
Do they have their own contractor's policy and stuff?
They get their own business card. Do they have their own contracts and agreements? Do they have their own client lists and customers?
What about if they can only put your name on their truck?
Well, that looks like an employee.
Because that's been brought up.
Right.
I mean, I've seen people say, well, I don't want my subcontractors working for somebody else.
Right.
I don't want my subcontractors on my job soliciting other work either. That work has to come through me. I've seen all that.
Oh yeah. Well, and here's another classic example that relates to workers' comp that employers do that drive me crazy. And I'll just use you for example. Somebody gets hurt on the job. You go to them and say, hey, look, we don't want to file any worker comp claim on this. We'll take you down and get you fixed. We'll take you to the hospital. We'll do whatever it takes to get you fixed. Well, that's mighty Christian of you. It's super nice of you. But workers' compensation is designed to protect the employer from lawsuits. That's one of the reasons it was established. And it's called the workers' compensation bar. And so the way the workers' compensation bar is just you paying the premiums, this person gets hurt on the job, they file the claim, and they get the medical care and treatment they need. The second you circumvent this, and this occurs all the time, the second you circumvent this and say, hey, look, I'm not going to, you don't have to file the claim, I'll pay it. You're not protected by the bar anymore. You're not protected by that bar. So if that employee had a head injury, they then can come back and sue you for the head injury because you're not protected by that. And this occurs so many times.
Is it illegal to do that?
Well, it's not following the law. It's not following the law. Nobody's going to do anything to prosecute you as a crime for that. You're just exposing yourself to liability that you shouldn't otherwise be.
Undue liability.
Yeah, that you
and the
shouldn't.
reason, so there's a lot of reasons people would want to do that, right? And you know them all, I'm sure. I mean, it's all about safety ratings and work comp ratings and stuff like that, and OSHA 300 logs and all that stuff. And those are the reasons people don't like to have frivolous, I need 2 stitches in my finger.
So what I tell people that are I tell employees, I said, look, you can't afford to be on workers' compensation. It just doesn't pay enough. You got to get healthy and you got to get back to work. So if we know as an employee workers' compensation doesn't pay enough, but you have commercial general liability insurance, right? Because most contractors, that's another decision you have to make when you start your company about whether you're going to have commercial general liability insurance, and the answer is yes. But you have commercial general liability insurance. It has a policy limit, I don't know, but of at least $1 million. That's usually what it carries. If he can get past the workers' compensation bar for whatever reason, then he can sue you, not you, but your entity, your LLC, and then try to get at that commercial general liability policy and get paid off on that particular claim. When you become a small business owner, you get attacked from all different angles. And so what you're really trying to do is every step you take, and why you have an accountant and why you have a lawyer, is every step you take is you're trying to protect the entity. Because what you're in business for is to provide service to people that they need so that you can provide a living for your family and your employees. That's what you're there to do. And so you have all these other distractions of, I personally feel, things trying to attack the business. But if you set the business up right, you can kind of avoid those headaches. not only is workers' compensation an issue, but unemployment's an issue, all right? So what you'll have is you'll have an employee. Now he's going to be an employee. He's not going to be a 1099. He's going to be an employee. So one of the first things that we have to establish is in Wyoming, all employment's at will. At will means that they can come and go as they please, and you can let them go or keep them as you please. There's no requirement that there's for-cause termination if the employment's at will. What changes that? Well, I've already told you can have an oral agreement, so oral agreements can change that. Written agreements can change that. And so you need to be careful with those employees on how you treat them, because you could be creating a contract for which they could sue you for breach. So you say, well, how do I protect myself on that? Well, you protect yourself on that with an employee handbook. And so who should write your employee handbook? But your attorney should write your employee handbook. It should outline all those things that are necessary for your employment.
Have you reviewed our employee handbook?
I don't know.
You should have Veronica send you that.
I don't know that I've reviewed your employee handbook.
We'll find out how bad it is.
I've written several employee handbooks, and so what you have to be cognizant of in employee handbooks is you have to be cognizant of federal law and you have to be cognizant of state law. And the most prevalent federal law that hits you is Fair Labor Standards Act, so that's overtime wages, and any types of discrimination. Discrimination can affect you. Now you have to have a certain number of employees for the federal laws to apply to you in regard to discrimination, except that state standards are less than that. So as long as you have 2 employees, discrimination laws apply to you. So you got to have the employee handbook. The employee handbook, though, under Wyoming law can be construed as a contract. So the first thing on the first page is you have an at-will disclaimer, and they sign an acknowledgement on the at-will disclaimer that says, hey, I acknowledge that I'm an at-will employee and that this is not a contract. This is just a guideline of how this business is going to operate and the things that I need to do to be a part of this business. But it's not a contract for me.
That's a good one. I don't know if ours has that.
Well,
I'm going to have to look.
Well, this is why it should have it, and this is why you have to have that. Because once you move into unemployment, how do you fight an unemployment claim? You have to prove misconduct. Well, misconduct between a supervisor and an employee and as defined by law are different things. So if Craig Silva's working for you and he does something stupid or negligent, you might think that's misconduct. For example, Craig Silva might put gasoline in a diesel truck. I've had a case like that. But that doesn't mount to...
I think I did that once and I didn't fire me. It was a bad day, but I didn't fire me.
But you might fire an employee, but that doesn't rise to misconduct. Misconduct has to have a rule. You have an existence of a rule. That's why we have the policy manual. You have the existence of a rule and a clear violation of that rule that amounts to a willful conduct, that I intended to do that. And simple negligence doesn't rise to that level. So that's why you got to have that employee handbook so that when you go fight your unemployment claim, you can say, hey, look, here's the rule. They didn't follow the rule. And because they didn't follow the rule, they don't get unemployment because it's misconduct. What a lot of employers try to do is they try to set up what's called a voluntary quit. Okay? So they make the environment so hostile.
Yes, that's something that comes up.
Yeah.
That is absolutely like, I don't really want to fire them because I don't want to pay the unemployment. I just want them to go away and disappear into the scenery.
Right. So they make the environment so hostile that the employee ultimately quits. They have a witness to say, hey, they voluntarily
cut pay.
Yeah, they
make them miserable. Worst task in the job.
Yes, make the job horrible.
This is my designated hole shovel outer.
Yep. They say, do you see that pile of dirt there? On my first construction job, this is true. The boss said to me, he said, do you see that pile of dirt? I want you to move it from here to here. Now, I was dumb. I didn't know. I moved it as fast as I could. But it didn't need to be moved, and we used a hand truck. I used a shovel, but we had a tractor that could have done it. But you make the job so miserable that they ultimately leave. So that miserable quality, though, can't be based on impermissible categories. We can't discriminate against them because of their race, their religion, their national origin, their gender, their transgender nature. We now can't discriminate against any of those categories. I mean, when you start your own business, it takes a lot and you learn a lot. The problem is we only really get good judgment from poor judgment. So we make mistakes and we learn from them, and then we tend to have better judgment as we go forward. So, you know, when you're interviewing employees now, when you sit down and look at an employee, you look at a couple different things. What are they going to be able to provide me in the future? Are they just going to be a headache for me and ultimately an unemployment claim and a workers' comp claim and whatever other claim they might be? Or are they going to be somebody that can make my organization better? Because really all you want to do is grow your organization, not just for you and your family, all right? You're growing your organization for you, your family, and your employees' family, because you provide them what? You provide them work, you provide them insurance, you provide them a means to have meaning in their life, to be productive. I mean, when you're a small business owner and you do those things, hugely important. It runs the nation, quite frankly, and people don't give you guys enough credit for that.